morning, Mr. Coughlin.
Your Honor.
Are we in the record? All right, we're on the record today. Have a seat, Mr. Coughlin. In case 13 CR 03914 and 13 CR 03913, the city is represented by Chief Criminal Deputy District City Attorney Dan Wong. Mr. Coughlin is present himself. A little bit of a record.
Your Honor, if I may interject.
No, I'm
guys.
not interrupting. Have a seat, Mr. Coughlin. Don't interrupt me. You'll give him a chance. We're going to conduct this in an orderly proceeding, not full of interruption. We're going to make a record first.
I just needed to file a motion to disqualify.
On September 18th, 2013, Mr. Wong was present, Mr. Coughlin was present. This matter had been transferred to me. Judge Dilworth had disqualified himself. We set today as a date to deal with any and all pretrial motions to address final discovery. And the trial date is set for next Tuesday at 9 o'clock, October 29th. I urge that all pretrial motions be filed no later than 5 p.m. on August 10th, 2013. So, now's the set. Now, Mr. Coughlin, what do you have for the court?
Yes, sir, Your Honor. I had requested to be able to file something this morning. And, it's my understanding that the court controls that when somebody can get me for court, I'd be able to do that. So,
what do you have? Do you want to file?
It's a motion. Respectfully submitted, Your Honor. It's a motion to disqualify. I ask that a copy be served on the chambers.
Let's do this. Let's make 2 copies. Let's file one with the court. We'll give one to Mr. Wong. And we have a whole slew of motions we'll take in an orderly fashion here.
And Your Honor, if I may just submit this motion here, if I didn't write it down, it is submitted in good faith and not for the purposes of delay.
Okay.
I ask that be read. Notice be taken to that, and an allowance to make any amendment that is necessary to include that phraseology within this motion.
We'll get to this motion in a timely fashion. Okay, first thing I want to talk about is discovery. It's my understanding that not only the record I'm looking at is that Mr. Coughlin, the city filed with the court in both cases a notice of witnesses pursuant to NRS 174-234, indicating that they intended to call, they could call in their case in chief any individuals identified by name in the discovery provided, which is the Reno Police Department report. In addition, Laura Peters is included in the State Bar of Nevada. Clint Player from the Washoe County Sheriff's Division is listed as witness number 3. Deputy Sojourn Walker from the Washoe County Sheriff's Office is witness number 4. Detective Tom Turbity, that was listed as witness number 5. And that was mailed to you at your 9th Street address on May 9th, 2013 in both cases. Additionally, I provided copies to you at the September 18th hearing of both the notices of witnesses, so that's been completed. The record should also indicate that Veronica Lopez, who was Judge Howard's judicial assistant on March 19, 2013, provided to you a copy of the summons, a copy of the criminal complaint, a copy of the amended criminal complaint, a copy of the declaration in support of the summons, a declaration of probable cause, a copy of the... Don't interrupt me, please. Let me finish.
But I'll have an opportunity.
Would you extend me the courtesy that I extend everybody else with not interrupting? I'm going to give... We can't conduct proceedings with you just interrupting. I'm going to give you every chance to address the court. But I'm asking you for the courtesy I give you. I don't think I interrupt you, nor do I interrupt Mr. Wong, because I have a thought comes to my head. Hold your thought, make some notes, and like always, Mr. Coughlin, I'm going to let you address the court.
Yes.
If you can let me finish, I'd appreciate the courtesy. The extended order for protection against harassment in the workplace issued by the Reno Justice Court was also provided to you on the 19th day of March 2013 in case 13 CR 03914, in case number 13 CR 09313. same documents were provided to you by Veronica Lopez, Judge Howard's judicial assistants. That consisted of when I say the same, it was a summons, a criminal complaint, an amended criminal complaint, a declaration in support of a warrant or summons, a declaration of probable cause, a temporary or a copy of the temporary order for protection against harassment in the workplace issued by the Reno Justice Court. Go ahead, Mr. Coughlin. Now go ahead. What you want to say?
I'm sorry, Your Honor. I need to get a lot better at that and not interjecting like that. And especially because I think one of the bases for what that interjection was about was you had used a term, Judge Howard's assistant, Veronica Lopez. The second time you said provided, the first time I don't believe, you said something but it wasn't served. The point I'm trying to make being that I didn't believe that the service was, it might not have been proper, but I do recall coming across something in the statutes specific to criminal law that seemed to say certified mailing of summons was sufficient. I do think where I haven't been able to access the court's files, and that's been a problem because I've never seen a return of service of that summons. And if the court has reason to believe that certified mailing was not signed for or otherwise not received, I think that might, in connection with the portion in 178 that says otherwise civil rules apply in RCP 4 context, maybe it's 5, B2 where a party, or in this case I guess the court, has reason to believe that service was not affected.
Well, there wasn't a service issue. She simply gave those documents to you back on September night, on March 19th. She handed them to you. So I'm just making a record that everything in the court file that we had at that time was provided to you in both cases.
In court?
Yes.
We had a hearing on March 19th.
Well, she gave them to you. That's what her certificate of protection documents. She says that, let me read this. I, Veronica Lopez, certify an employee of the Reno Municipal Court, Department 4, and I hereby certify that I provided the documents listed below to defendant Zachary Coughlin. So.
Well, I know I didn't see her on March 19th. I don't believe we had a hearing.
I don't know that. I'm just saying that, Mr. Wong, are those also documents you provided to Mr. Coughlin in conjunction with discovery?
Your Honor, I believe I have provided him all discovery that he's entitled to. In fact, I want to state for the record, we've gone over this issue before.
I understand.
The discovery statute says I only have to allow him to inspect and copy. I, in fact, copied them myself, and had my legal secretary serve him, give them to him, mail them to him. I also emailed the discovery to him. I believe that I have provided all discovery in both cases. But I also want to state for the record that I have received scores of emails from Mr. Coughlin with attachments with hundreds of pages.
And we'll get to all that in a minute. Right now, my inquiry is limited to whether or not you provided, it sounds like you either mailed and or emailed the same documents to him that were provided to him by Veronica Lopez.
I believe I have.
Okay.
Your Honor, if I may be heard on that. Just because I'm countering that she didn't provide them to me.
Okay.
Sufficient to satisfy.
Well, did you get them from the city attorney?
This
Mr. Coughlin, did you get those documents, the summons and criminal complaint, amended criminal complaint from the city attorney? Mr. Wong has indicated he mailed those to you and he emailed them to you.
I'm being prosecuted for specific technicalities with respect to how things were served or done or whatnot. Right now, the inquiry is not discovery. Which
No. The inquiry, Mr. Cullen, the inquiry is discovery. The inquiry right now is, did you receive those documents from Mr. Wong?
I believe that's attorney-client privilege, and the inquiry
All
is
right, you
served.
don't want to answer that? All right, Mr. Coughlin does not want to answer that question.
I'm saying they weren't served. I do not believe in accord with the statutes.
Mr. Wong has made a record that not only were those documents made available to you, they were served via mail to you, and they were emailed. So I'm satisfied that discovery is complete in this case.
After the arraignment.
All right, that's when it should be done, after the arraignment.
The service of the complaint and summons should be made after the arraignment?
as long as it's made sometime pre-trial. So that's taken care of, Mr.
At the
Coughlin.
arraignment, prior to the arraignment, I had filed a motion to quash service.
Okay. All right, well, the discovery is now complete. Mr. Wong has complied with the Nevada, you can have a seat, has complied with the Nevada law on the discovery. Mr. Coughlin, have you provided any discovery to the city attorney?
Your Honor, have we addressed whether service was appropriate or whether it was quashed? Am I getting a ruling on that motion?
Mr. Wong has indicated he provided discovery to you.
I'm not talking about discovery.
That's what I'm talking about.
Mhm.
I'm talking about that. He's made, not only has he complied with the statute by mailing to you, he has emailed the same documents to you. The city attorney he's indicated has made those available to you, and Judge Howard's judicial assistant has also provided all those documents to you. So I'm satisfied discovery is completed on behalf of the city. Mr. Wong or Mr. Coughlin, do you need discovery you want? Do you need discovery you have for the city that you have not provided to date?
Your Honor, if I can just quickly interject that I believe 80 KT 0411 requires another judge other than the presiding judge to rule on my motion for appointment of counsel. But with respect to that discovery issue, and that's the indigent defense order 1408 and 82K 411. With respect to that discovery issue, you said provided. It seemed to me at the last hearing you may have ruled that I needed to serve them on Mr. Wong.
Did you serve anything on Mr. Wong?
Due to my indigency, I've been having some issues with that, with respect to being able to afford postage and transport to go personally serve things. I've recently had the seat on my bicycle and the tire broke, and my car hasn't worked for a month now. So beyond that, as Mr. Wong has argued, I don't believe service is technically required, and I believe the court ordered that I serve it. But I also think that NRS 178.608, 610, and 600 specify that, as well as 178.589, specify that I'm able to fax serve the city attorney. In addition to RMC Rule 5D, I suppose, and there's some argument Mr. Wong's made with respect to that only applying to motions and pleadings. I submit that a court of limited jurisdiction does not possess the inherent authority or the rulemaking power to override NRS 178.589. But in that regard, I'll just respectfully submit, Your Honor, it's not out of a lack of respect for this court, any extent to which I haven't technically served Mr. Wong these materials, although I do believe email may qualify as a telecommunication line pursuant to 178.589 under the Telecommunications Act, regardless of whether one has DSL or a cable-based platform for internet access. In that regard, chief among my concerns is that Mr. Wong at some point might say, well, I didn't receive the JABS audio from the Reno Justice Court at the 1/4/13 hearing in the protection order at issue here, RCP 2012-607, where that is going to be of material relevance to my case is that I'll submit or make an offer of proof that Laura Peters told...
Okay, Mr. Coughlin, now we're getting way, way out there. We're issuing discovery right now, and it sounds like the city, I've made a finding, the city has compliance with the discovery requirements, and I'm hearing that any discovery that you may have had or intend to serve on Mr. Wong has been done, or you're not going to do it. Is that correct? I don't need to hear about Laura Peters at the state bar at this point. We're talking about your obligation to provide discovery to the city and related to any information you intend to produce at your case in chief next week at the trial on October 29th.
Well, if
That's
Chief
what I'm
Wong
talking
will
about.
submit that he's been served or otherwise provided sufficient to satisfy any this court may put an order on me that goes over and above Nevada law.
No, I'm not putting any order. Just asking if you've given him discovery. It's a yes or no.
At the last hearing, you said I had to serve him.
I'm asking you right now, did you provide him with any discovery?
I provided him with discovery.
Okay, perfect. Then you're in compliance too.
Have you heard on that?
Yes.
I dispute that. I haven't been provided with any
Okay.
discovery.
All right.
The city's position in both cases is we have received no discovery from Mr. Coffin.
All right, Mr. Coffin, your final word on the issue of discovery to Mr. Wong.
Maybe I don't understand what the term discovery encompasses. Mr. Wong, I believe, has received the Jazz audio of the extension hearing of the protection order at issue here. My understanding is that would fall under the purview of discovery.
Right. All right. Let's move on. Now, let's address right away, before I move any further, Mr. Coffin, you filed this morning a motion. Your motions are very difficult to read, but it was filed in this court on October 22nd. It was a handwritten motion indicating that you wanted to disqualify, and there's a declaration in support thereof, to disqualify me as the judge in this case. Is that correct?
Yes, Your Honor, and that's respectfully made, Your Honor. And that's
I understand that. All right. Let
more
me
as
just,
appearance of impropriety rather than any allegation of actual
I
impropriety.
understand, Mr. Coughlin, you're making a record. Let me just indicate this. When you were in court on September 18th, you filed and served the court with a motion to disqualify the judge. I made a ruling that the motion was not filed in compliance with NRS 1.235, paragraph 1, and or paragraph 1B. The motion was denied. However, I allowed you, I gave you leave to refile your affidavit in compliance with the statute. That statute, NRS 1235, which I have in front of me, provides that an action, any party to an action or proceeding pending in any court other than the Supreme Court who seeks to disqualify a judge for actual or implied bias or prejudice must file an affidavit. I will accept your declaration in lieu of an affidavit. It's pretty clear in my opinion, declarations filed under penalty of perjury, which apparently your declaration is, would comply. So that's the ruling that it is in compliance. That affidavit or declaration must specify the facts upon which the disqualification is sought. And you've indicated that the affidavit was filed in good faith and not interposed for delay. I'll accept that, even though there's not a certificate filed. I'll allow the record to take into allowance that you've made that motion in good faith. And it says that that motion, the affidavit, or which I'm also allowing the declaration, must be filed not less than 20 days before the date set for trial. So again, the affidavit or declaration is not timely filed. Trial has been set for next Tuesday, October 29th at 9 a.m. So you're not in compliance again with the statute. This is now part of the record. So the motion to disqualify is denied.
Your Honor, may I be heard on that briefly?
Briefly, go ahead.
Okay. With respect to the former ruling or approach to the last motion to disqualify, it was my understanding at that time maybe the Buckwalter decision in a declaration was not being accepted. The other basis was that it was not timely filed. I submit that one was timely filed with respect to this hearing. And
that was a motion. It wasn't a declaration or an affidavit.
it did have the language of the declaration there, and it combined.
The record, your motion is on file, and that is part of the record.
Okay. And then with respect to the timeliness of this, I'm sorry, Your Honor, just to make sure I understand. The last one was not addressed due to an indication that it didn't satisfy the affidavit requirement and that it wasn't timely at that time?
No, it was not. I didn't rule it wasn't timely. I ruled on September 18th that the motion, the document you filed with the court did not comply with NRS 1235, and it was denied at that time, and you were given leave to refile it so that it would be in compliance with NRS 1.235. What you filed today is now not timely filed because it's not less than 20 days before the day set for trial.
And with Your Honor, with respect to the timeliness of today, there is some newly discovered or new developments that I believe operate as exceptions to the timeliness requirement thereunder. Just to be clear, though, I seem to recall at the last hearing you indicating a basis. There were some varying bases. One of mine, I believe, was that I didn't, in the court's view, submit a short, plain statement of the bases.
No, I didn't rule on that. I ruled that you weren't in compliance with the statute. You didn't file either an affidavit or notwithstanding the fact the statute requires NRS 1.2351 provides that an affidavit must be filed. You filed neither an affidavit nor a declaration. That's what I ruled, because my notes are very clear. And I let you to refile your affidavit in compliance with the statute, gave you plenty of time to do it, and we discussed that on September 18th. And I'll also make this finding that I don't entertain any actual bias or prejudice against you at all, Mr. Coughlin. So.
Right, but it's not only actual bias that operates, it's implied bias, appearance of impropriety. The utility of your remaining on this case must be weighed against the extent to which an appearance of impropriety, regardless of whether there's not any actual bias or impropriety, must be weighed against whether an appearance of impropriety is such that the judicial system is better serviced to transfer this case.
Right.
And if I can just quickly address some of these bases.
Hang on, Mr. Coughlin. Let me just tell, I'm looking at your motion. It's very difficult to read. But the statute also requires the motion specify facts upon which the disqualification is sought. So you have a copy of this motion in front of you, do you not?
Yes, I could
Why don't you
enunciate this in 2 minutes.
Why don't you take 2 minutes then and indicate what in that, because it's so difficult to read, where in there, what in there, read to me from that motion the information that specifies the facts upon which the disqualification is sought by you.
Yes, sir, Your Honor. Primarily amongst those is the indication you made, I believe it was at the 410, or the 410-12 hearing in 26405, wherein you indicated that you passed the 41309 order from your sister in that Yoshi divorce case, DB08011168, around to the other RMC judges, including those who were then presiding over.
No, I never said that. I provided a copy of that to Judge Holmes. I didn't pass it around to anybody. It's a public document that was received by me, which I forwarded to Judge Holmes, who at that time was presiding over one of your cases. So I didn't pass it on to any of the judges. I provided it on to Judge Holmes. And that disclosure, by the way, has been consistently made by this court, and I made that prior to the trial in your trespassing case some time ago. Go ahead.
I apologize for that, Your Honor. That is refreshing my memory somewhat, but I do believe Judge Holmes then admitted to passing it around to the other.
May or may not be true. This court does not have any first-hand knowledge.
I do know that to be true, and this court, beyond that, even passing it to Judge Holmes, I had the traffic case in 11 TR 26800, which that was an extrajudicial source. It poisoned the well with Judge Holmes against me. Furthermore, that order by your sister was vacated. Your sister, after I was fired from my job at Washington Legal Services, she entered a final decree of divorce that did award the very alimony that her 41309 order suggested I was vexatious in pursuing. And she vacated the attorney's fee award as well that was ostensibly made under NRS 7.085. Furthermore, amongst the bases is that this court on 41012 and 26405 failed to recognize the mandatory stay inherent to Judge Holmes's fellow department in this court's finding that my competency was in question in the 22812, 31212, and orders in that 26800 traffic case and her 31412 letter to the State Bar wherein she alleges that all the RMC judges, including yourself, Your Honor, were grievance against myself. So to the extent that Judge Nash Holmes has been conflicted out of this case, I'd submit that same on the basis of her either being a grievant or being a witness, is I believe what you indicated at the last one, I submit that same rationale would operate to conflict this court off of it. Furthermore, especially to the extent that the filings in the trespass case 26405 of 3712 and 6512 by myself were provided by this court to the State Bar of Nevada. I asked that all the materials in my 9/18/13 motion to disqualify be incorporated herein by reference. The last couple bases enunciated in this, as you asked me to read off this, include what I believe is an SCR 121. I think it's sub 10 or 11 violation in that you, Your Honor, indicated extrajudicial knowledge at the 4/10/12 hearing at 26405 with respect to my formal disciplinary matter. At that time, you indicated you believed that screening panel was meeting on 4/10/12. That's somewhat murky in the extent that I think individuals or grievance at least are allowed to ask the status of a matter from the bar, but to the extent you were not a grievant.
Okay, Mr. Coughlin, I want you to stay focused. What happens if I let you ramble on for 15, 20 minutes, and it becomes hard to follow any legitimate points you're trying to make? I have made the finding that your motion was not, your declaration was not timely filed. I'm also making a finding that there's nothing in there that sets forth a basis to disqualify me, so that motion is denied, and it's going to be available for review at a later date. So,
Your Honor, if I may, though, quickly just address
quickly, I don't want you to get on a big long rambling diatribe, because when you do that, we all lose track of where you're going and what you're trying to say. But go ahead. Try to stay focused and try to stay brief.
New developments or newly discovered bases for asserting a conflict or a basis to disqualify operate as an exception to the timeliness requirement. And this court, I believe, has a duty of supervision over its marshals and any clerks, and in fact any deputy clerks that it has appointed pursuant to NRS 4.3536, particularly in light of NRS 281.340. In that regard, the failure of this court marshals to accept my filings and the refusal to afford me access to my files in this court.
For the record, on May 1st, you filed several motions with the court. This is where the motions become more difficult to understand. Do you know how many motions you filed on May 1st, Mr. Coughlin?
I believe at that time, Your Honor, I submitted 2 motions to Marshal Copa. There was some confusion in that regard, so I believe with respect to, I think basically I submitted one long one with one of the case numbers, and then basically a one-pager with the other case numbers.
Okay, correct.
Please incorporate by reference.
Okay, you're on May 1st, 2013 at 5:34 p.m. You filed a one-page motion that's amended. It's a motion to quash service, motion to dismiss, motion for continuance of arraignment, motion to compel police reports, motion to set aside finding of probable cause, notice of interlocutory appeal to finding of probable cause, motion to vacate notice setting hearing, motion for continuance should trial date of May 23rd not be vacated, which it was, notice of non-service of notice setting hearing, motion to proceed in form of pauperous and declaration of financial condition in support thereof, and motion for attorney's fees to be self-representing counsel, motion to disqualify the Reno Municipal Court and Reno City Attorney's Office, notice of NRS 178405, mandatory stay in light of the suspension of trial, and 11 TR 26800, and then your motion is 4 pages, and that was the May 1st. Then, on May 2nd, filed a second motion at 346, which is a 127-page motion, which is an amended motion now, which is identical to the motion filed on May 1st. It was simply filed on May 2nd. And attached to that motion was 127 pages of rambling diatribe. In fact, on each page, there are 4 reduced pages, which I did read. Judge Dilworth indicated he had trouble reading. I actually spent the time reading them. That's a 127-page motion, which consists of a lot of various items. Then on May 2nd, 2013, at 4:01 p.m., you filed a 1-page written motion. Do you recall that one? The motion to correct filing date on May 2nd, amended supplemental motion to quash.
You're saying that was on May 2nd?
That was May 2nd at 4:01.
I do recall that. And
Right.
just briefly, Your Honor, the last one you referenced was, you said it was 127 pages, 4 per page, and that was 5-1.
Well, some of the pages are full pages. Some of the pages are, if not most of the pages, are 4 pages that have been reduced on 1 page. So this probably is around 400 or 500 pages. The actual 127 pages are very difficult to read transcripts. And what you did is you reduced 4 8.5 by 11 to 4 of 1 page.
And that's 5-1, was that one?
That was May 2nd at 3:46 p.m.
So that's not the 2 that were filed on 5-1,
You filed 1 motion on May 1st.
just 1.
Let me make sure. Correct. I have it in front of me, and these were the 2 you filed on. The one on May 1st was a 1-pager. And just amended the 5-2, which is odd that it was amended given the fact it was filed first. And on May 2nd, you filed a motion to correct. All these directly relate to the 127-page May 2nd, 3:46 p.m. motion.
Your Honor, if I may just quickly indicate, I believe that 143-page motion you just
127 pages.
127 pages.
That's one of the smaller ones.
I believe that should be, I don't know, it might matter here in some regard, dated May 1st. When I said earlier that I submitted 2 documents for filing on May 1st, one long one and then basically one that was 1 page that asked to basically incorporate the long one into that one, in case we got into this thing where I'm required to submit 1 filing for each case number. Basically, I was trying to avoid having to print that out twice.
Okay.
And so for the longer one to be given a 5-2 date, whereas it seems to me that to whatever extent there's some kind of timeline, deadline involved here, that the long one should be given a 5-1 date, the 1-pager should be given a 5-1 date, and then the motion to correct filing date would be something I made on 5-2.
Well, I think I can figure out what's happened. All 3 are incorporated. They're read together. They're taken together. They directly relate to each other. I've read this motion when I was first assigned the file. The motion is denied. It doesn't set forth any legal basis for relief, which is supported by the law or the facts.
Well, if I could be heard on
That's
that,
the
Your Honor.
finding of the court.
Can I be heard on that?
Go ahead.
I'll just note that you've denied it. Pretty much every motion I've ever made in front of
Well,
you.
let me make a comment. Every motion you filed in front of me to date is, some of them are so difficult to understand, I don't understand them, but just because you file a motion doesn't mean it has legal merit. And the motions that I've reviewed by you, not all of them, but most of them don't have any legal merit. You don't get to file 20 motions and win 1 or 2 based on pure numbers. Some of your motions that I haven't even got to, I've granted you. When you made an oral request for the copy of the proceedings, I mailed you a thumb drive. When you requested discovery, I ordered that the city comply with discovery and provide you police reports. So that's, your comments are not correct. Most of your motions have been denied because, in my opinion, they have no legal basis on which to grant relief.
Your Honor, the inquiry set forth in that with respect to, one has a constitutional right, especially when they're in a lawsuit. And this goes to Ms. Peters' fraudulence here. She tells the police she's a paralegal. She doesn't mention she's a clerk of court. And then she also lies about, well, I couldn't see who was in the car, and the police report is conferred by uturity. And then she shows up at the extension hearing and says, oh, I can see it was Coughlin in the car. But with respect to one has a constitutional right, and this is embodied in the statute. I believe it's NRS 33. I want to say 470. It might be 360, where it says constitutionally protected activity does not violate the protection order. One, even if I had done what is alleged here, that is absolutely constitutionally protected. There's a wealth of authority that I set forth in that motion.
And you know, Mr. Coughlin, I don't know, because I haven't heard a grain of evidence yet on that case. The only thing I know about this case is what I read in the criminal complaint, what I read in the declaration in support of the summons. So those are issues that are, you can certainly feel free to raise those issues at your trial next week. Those are questions of law and fact that we will deal with on next Tuesday at the time of trial.
Well, the State Bar admits in the materials you referenced earlier that those are filings in a case pending there in the State Bar.
So what?
So
What does that
there's
have
no
to do
need
with
to go to
anything?
trial on this. That's constitutionally protected.
That's a ruling. That's a ruling. That's a defense you can assert at your time of trial, and that's a ruling I'll make at time of trial after I hear all the evidence. Mr. Wong?
I will just briefly say, Your Honor, that there is an order in this case that Mr. Coughlin is collaterally precluded from attacking the basis of the correction.
Yeah, that's right. Judge Dilworth, Mr. Coughlin, as you are aware of both cases, in this matter, by the way, you submitted a very legible, understandable brief in your opposition to the motion in limine filed by Mr. Wong. In the Truesdell case, the Supreme Court in the state of Nevada clearly, that's at 129 Nevada, as cited April 14, 2013, clearly held that a defendant charged with violating an order for protection cannot collaterally attack that protection order at trial.
Your Honor.
The Supreme Court indicated that the party must challenge an order for protection for the court that issued the order and may not collaterally attack the TPO's validity in subsequent prosecution. So that matter has been addressed, briefed, well briefed by both you and Mr. Wong, and decided by a dated order of June 28th by Judge Dilworth, which I agree with. The Truesdell decision is very clear. So any issues related to the collateral issuance of the temporary protective order will not be discussed any further by this court nor at the hearing.
Yes, sir, Your Honor. If I can just briefly be heard on that. Mr. Wong was duty to candor to the court, and Judge Dilworth's ruling in that, and the Truesdell decision is limited to the validity of the order. There's three distinct treatments under the law with respect to collaterally attacking orders. Validity is only one of them. An order being void is an entirely distinct characterization, and an order being voidable is another one. Further, I was not just now referencing a collateral attack on the order. What I was referencing is statutorily based, where it says it's not a violation of the order if you're engaging in constitutionally protected activity, such as filing a document.
Mr. Coughlin, your 127-page motion speaks for itself. It's detailed, it's lengthy, it's amended, it's supplemented. I've denied it. The record is clear. You can certainly raise those issues on appeal, but we're not going to have any more argument on that. Your motion that was filed has no legal merit, in my opinion.
Well, but you said it's.
Well, I'm not going to listen. I'm not going to get up here and argue with you about my rulings. You can appeal those rulings, but that's the court's ruling. Now, we come to the next motion you filed on May 13th. Do you recall which motion that was, Mr. Coughlin? Do you have a copy of that?
Yes, I do. I believe it was. It had a motion to bifurcate.
No, this was a 218-page motion. I counted every page in that motion. That was filed on May 13th, 2013 at 9:01 a.m. It was, I'll read this into the record. It was 218 pages. Again, a portion of that motion contains, if not most of it, contains 2 pages that have been reduced to 1, not 4. And very difficult to read, very rambling, but nonetheless I read that motion as well. That was an amended or supplemental motion to quash service, motion to dismiss, motion for continuance, finding of probable cause, the exact type of motion that was filed by you on May 1st. It just, instead of having 127 pages, it had 218 pages, which, when you go through and look at this, this is about 1,000 pages contained in this very lengthy, rambling amended or supplemental motion. Mr. Wong responded to all these motions, opposed those motions.
I've never seen one bit of legal analysis or authority put forward by Mr. Wong to rebut the contention that constitutionally protected activities such as filing a document in a lawsuit is somehow violative of a protection order.
Okay.
And under DCR 13.3, his failure to rebut that is taken as admission as to the merit of the argument.
All right, that is noted for the record. That motion, which really is very difficult to follow, Mr. Coughlin, it doesn't set forth any legal basis on which to grant relief. Your 218-page motion was denied. That's part of the record. That brings us to our next motion filed by you.
Just to clarify, Your Honor, that was a motion to bifurcate as well?
No, that was essentially the same motion you filed on May 2nd, May 1st, which you characterize as an amended motion. You simply apparently attached about 200 more pages of rambling argument, rambling nonsensical argument to that motion. So that's what that motion was.
And there's not an interlineation next to the title of that document that says a motion to bifurcate?
No, you weren't getting to that. You filed a motion to bifurcate. That's a different one. You filed so many motions in here, but I have them all in front of me. On May 13th, 2013, you filed a 27-page motion, and that is your motion to dismiss, motion for continuance of arraignment, motion to compel police reports. It's the same motion that was filed on April 17th, but you added by written interlineation the motion to bifurcate the trials. Mr. Wong, in both cases, filed his opposition to the motion to dismiss. And Mr. Coughlin, I'll give you a brief opportunity to indicate why at this 11th hour, 6 months into the case, I should not bifurcate these trials that stem out of conduct earlier this year. Go ahead.
You're saying at this 11th hour, as though my filing this at 5:13 is somehow tantamount to my filing at the 11th hour?
No, you're right. Go ahead. I retract that statement. Go ahead and tell me why I should bifurcate these trials. What's the legal basis to bifurcate them?
I think it's
The motion's very difficult to read. Again, the motion speaks for itself. The motion contains 2 pages on most every page. And a lot of it just, again, starts to reference justice court matters,
I think they're
privileges, exemptions.
I don't know why these were given separate case numbers in the first place, but rather than charging someone with 2 counts in the same case, but to the extent that these are being treated as separate cases, I think it's prejudicial because there's a tendency to lessen the due process given to either of them when they're joined together. It becomes essentially what I would characterize as a bit of a twofer, and where I'm certainly being subject to an order where I'm required to file a copy of, let's say I want to file the same document in each case. Your order at the last hearing was that I need to file a copy thereof in each case, despite my indigency, despite the presumptive threshold being met, where I'm receiving food stamps, I make less than 200% yearly, and less than 200% of the federal poverty guideline yearly
That
income.
didn't seem to impact your ability to file a 127-page and a 218-page motion.
Well, it did, because I had to print it off at 4 per page, which you at length commented on how difficult to read it was,
But I read
and
it.
all that. And if I hadn't been indigent, I could have done 1 per page and things of that sort. But my indigency affected my access to paper, my access to ink. Further, this court provided me an 8 gigabyte new flash drive that retails for $14, rather than accepting my offer to accept via email a copy of the audio of the 9/18 hearing. So all the remonstrance directed at me with respect to budgetary considerations and judicial economy seemed to run counter to that practice, providing me a $14 flash drive in lieu of emailing something to me. Got a little off track there.
Bifurcate. Talk about why the matter should be bifurcated. Let's get back on track.
I think, one, the TPO, if that fails, especially if the service of process thereof fails, the 1226 purported service by a bailiff, where the protection order specifically provides who is allowed to serve that. Further, a justice court bailiff is not there amongst the law enforcement entities set forth therein. In addition to the courthouse sanctuary violations and things of that sort. But if the TPO trial, if the service of the TPO or the TPO is deemed not to have somehow, the TPO is the source of the notice of the extension hearing on January 4th. So in that regard, I think it might make sense to bifurcate these to the extent that the...
Okay, you're starting to get, you've made some points, but when you get so long and rambling, I start to lose track of where you're going with the motion. I don't think you need to make arguments for 10 or 15 minutes. I think you've made your point on the bifurcation, and I don't want to cut you off, but as you begin to ramble, I begin to lose focus of where you're going with your motion. It makes it difficult to rule when you become unfocused. So if you'll stay focused on the legal reason, I can, the record, I think, is easier to read and understand.
Yes, sir. And just to clarify, before my motion to dismiss for the speedy trial, right, and out of custody, defendant not arraigned or within 45 days, I believe, of I believe there is a basis for finding that the speedy trial right was violated.
Okay, we're talking about bifurcation. Let's focus on bifurcation. Let's stay focused.
I don't believe there's all that. There's not much reason to combine these, which has been the case. To make a defendant put on 2 trials, they're both set for the same time, it's prejudicial. If
this were a jury trial, Mr. Wong clearly in his opposition sets it up. There might be arguably some danger that a jury could be influenced by the fact that you're facing 2 separate criminal charges. I'm in a position where I can easily take a look and compartmentalize the issues in case number 13 CRO 3914 and 13 CRO 03913, and I can do that. I've been doing this for 30 years, and I don't think I'm going to have any problem
you've said
hearing
that.
both those cases at the same time.
You've said that, but you haven't been a judge for 30 years.
No, I haven't, but I've been in the business for 32 years.
Well, but it's different, right?
Okay,
Being
Mr.
a judge
Coughlin?
and prosecutor are different things.
And I've also been a defense attorney, and I've been an attorney in private practice like you, and like Mr. Wong. So I've been at this business for 33 years. I'm not going to have any problem compartmentalize these. Your motion to bifurcate is dismissed, is denied. The motion to compel police reports referenced in the motion filed on May 13th is moot. I've already ruled on the other motions to dismiss, and those are denied. The record is clear on that. Now, you then filed some type of pleading on September 12, 2013, handwritten, and it says pursuant to Administrative Order 2013, I am writing to request time to view files 11 CR 22176, 11 TR 26800, 12 CR 00696, and 11 CR 26405. What do those have to do with these two cases?
Well, one
What do they
might
have to
be,
do with any of those?
what's that? Well,
What
you're
do
the
you need?
administrative judge here.
No, my question is not, I know I'm the administrative judge. My question is, what does these two cases we're here for today have to do with those other cases?
Well, I mean, it definitely goes to my ability to put forward a timely motion to disqualify where I'm precluded from accessing any of those cases, particularly where you're functioning for these last 2 years as the administrative judge here, and NRS 189.0307 has been violated in numerous instances, costing me my law license, where Judge Howard, and he might have been the administrative judge at that time in 2011, tail end of that, he failed to transmit the transcript, which is required within 10 days, regardless of whether any down payment is made. Someone who's been held out as the sole court reporter or sole voice transcriber, she's not a CCR, is my understanding, that I'm permitted to use with Reno Justice Court Pam Longoni, hung up the phone on me twice and refused to produce the transcript. As required by 189.0307.
Those cases have not, I'm making a finding, those cases have nothing to do with these two pending TPO and EPO cases. You've also been giving documents. In this case, every document that we have in this case has been provided to you, either by the court, from the city, or you have...
Now the docket required incident to this being a court record.
Here's the docket right here. I'm giving to you right now, Mr. Coughlin. In both cases, I did rule on one of these where you did request the docket. I'm providing to you a copy of the docket, which is very limited. It simply outlines in a 2.5 page, 2 3/4 page orderly fashion the case summary in 13 CR 03914 and 13 CR 03913. So let's make the record that Mr. Coughlin's getting a copy of those. I don't know what value those are, but there you go.
Well, one of the values is pursuant to this being a court of record. It's required by the ordinance RMC 2.16080, which I believe is constantly violated wherever a transcript is not ordered. Now, you did order the transcript in 26405. I'll note that. But further, Judge Nash Holmes she's stricken 2 notices of appeal, which is my understanding is not permitted, especially under...
Those cases have nothing to do with what we're doing here. Now, you're getting again so out in left field on these old traffic cases, which have never resulted in a they have nothing to do at all with this case today. We're not going to have any further discussion. There'll be no further discussion regarding an old traffic case going back 2 years to the cases we're facing here on these EPO, TPO violations.
Well, Your Honor, I'll respectfully submit that 178.405 NRS states that where she suspended that traffic case incident to a finding that my competency was an issue, all departments in this court...
No, I checked on that. There's been no written order from Department 3 suspending any of the proceedings in this court based on your competency. I'll make, unless you can show a written order to that effect. Otherwise, I did check on that. I told you I would check after the last hearing. I did. There's no order, written order related to your competency in terms of mental health issues.
Judge Nash Holmes specifically indicates serious mental health issues in one of her orders.
If you can produce a copy of a written order that's required.
Well, I'd ask you to take judicial notice of the 228, 12, and 312, 12 and 313, 12 orders, and 11.
I spoke to Judge Holmes there and I reviewed the files. There's no issue related to your competency. So anyway, you've been given a copy of your docket sheet.
At the 11th hour.
Notwithstanding the fact that the production of documents was given to you about 4 months ago, 5 months ago, 7 months ago by Judge Howard's staff, notwithstanding the fact all items of discovery have been provided to you months in advance. All right, Mr. Coughlin, the next document filed with this court is August 10, 2015, where you filed this on October 10th. Request for the documents.
Your Honor, if I may be heard.
No, I'm not. Listen, you're interrupting me again.
You're not allowing me to be heard. I understand.
Thank you. You're interrupting the court again. You've made the record.
No, I wasn't permitted to.
Your request for your docket is hereby granted and your motion filed October 10th. So that is resolved. And then finally, and Mr. Wong did oppose in that motion as well, which is very difficult to read, but nonetheless I was able to read it. You then filed yesterday, or rather on October 15th, you came to the court in both cases. And filed what you apparently did, and let me give Mr. Wong a copy of this, and there's Mr. Coughlin a copy, and both of you are getting copies of what Mr. Coughlin brought to the court. You took a justice court form, scribbled in Reno Municipal Court, scribbled in City of Reno over State of Nevada, and made a request for the appointment of a public defender. That was filed on October 15th, 2013. My pretrial order in this course, in this case, already set deadlines for the filing of all motions. And these two pleadings are not in compliance with those motions. All pretrial motions needed to be filed no later than 5 p.m. on October 10th, 2013. You've been filing motions since back in April, so you've had plenty of time to file whatever motions, and these are both not timely filed. You want to address the problem of either one of those motions requesting a public defender, a motion for NRS 178-405 stay recognition per February 28th, 12 a.m., March 12, 2012, 11 TR 26800 order. I don't understand what that even means. You want to make a record on that, Mr. Collins?
Well, Your Honor, with respect to your timeliness contentions, this court's violation of Knox v. District Court and NRS 178.600, 608, and 610 incident to these 1/16/13 Administrative Order 13-01, as well as the marshals refusing to accept my filings at times prior to the October 10th, 2013 deadline, certainly operate to rebut the contention that this request, which is not a motion, with respect to the request for appointment of public defender aspect of it, is not timely.
Well, how is it timely? I told you to have all motions filed by October 10th. This is received by the court on October 15th.
Well, to take a page out of City Attorney...
No, I'm asking you, why is that, how is that in any way a timely filed motion?
Well, I'm answering that to take a page out of City Attorney Wong's book where he says, well, Reno Municipal Court Rule 5 says motions are pleadings. When you file a notice of appeal, that's not a motion or pleading. So this court, which was a basis for my seeking to disqualify yourself, Your Honor, is that the appeal in 26405 was dismissed incident to this court failing to transmit my fax filed motion.
That case has nothing to do with this case at all.
Well, it creates an appearance of impropriety.
Maybe on your behalf, but not on mine.
Now, based upon this court's conviction, which I didn't get appeal because this court failed to faithfully fulfill its duty to transmit the notice of appeal, subject to NRS 189.010. Now, this is a request for appointment of public defender. Going back to my analogy to Mr. Wong's argument, a request is not a motion. So, you said all motions are due.
You can characterize them in any way you want to characterize them. When you call them a motion, a request, a this or that, it's in violation. Let's talk about that. We don't utilize the public defender. And in this court, our court, in past cases, Mr. Coughlin, at your request has provided court-appointed counsel to represent you. And every lawyer that's represented you has asked the court to be relieved of counsel because the attorney-client relationship has broken down. It broke down with Mr. Puentes. It broke down with even with Mr. Loomis. It broke down.
I thought all these cases weren't relevant to what we're doing here today. That's what you told me.
Let me finish, Mr. Coughlin. Quit interrupting me.
Yes,
I don't interrupt you when you're up rambling, do I?
You're correct.
I try to give you some courtesy I think you're entitled to. That's what I try to do.
That's true. I'm sorry, Aaron.
All the lawyers, Mr. Sotelo, Mr. Loomis, Mr. Puentes, that we've appointed in past cases to represent you has resulted in a breakdown of the attorney-client relationship, a delay of the proceedings. And in fact, on the trespassing case, it came to a point where you were asked to represent yourself. So to appoint any lawyer to represent you at this time would simply delay the proceedings again. We're not going to do that. This motion and this request, whatever you want to characterize as a request, is not timely filed. It's 1 week prior to trial, and it's not made in good faith, and it is made for purposes of delay. So the motion itself simply, Mr. Coughlin, incorporates, by the way, a very rambling diatribe about Judge Glasson and the case pending, whatever case that is, in the Justice Court, I don't know what it is, has nothing at all to do with this case. Apparently you just scribbled Reno Municipal Court on a motion and filed it. So those requests are both denied. Now,
May I be heard on that?
go ahead.
The attachment therein references 189.0301, which applies incident to NRS 5.073 in light of the Reno Municipal Court being by Ordinance RMC 2.16080 made a court of record, thus requiring, like justice courts, which pursuant to something in the Nevada Constitution are all characterized as courts of record, requiring the transmission of the transcript and all related papers in these cases within 10 days to the district court. This court has not done that in a variety of my cases. I apologize for interrupting you earlier, Your Honor, but with respect to the fact that you were referencing other cases, but I do think that's key here. Is I've on a number of occasions this morning attempted to reference other cases, and I've continually been told they're not relevant. Now, in addressing this request for appointment of public defender, which you said was made a week prior to trial, where I see it stand for
October 15th, it was made 2 weeks prior to trial.
Okay.
I stand corrected, and you are correct.
I know this court holds trials within a week of providing the defendant's discovery at times. So I submit that I don't know how this would result in a delay, particularly if where this court could simply refuse to grant a continuance to whatever extent any court-appointed counsel, which, by the way, incident to 80K 411 indigent defense order, that appointment would need to be made by somebody other than the court. Such an indigent defense order took appointments out of courts entirely, I guess.
Problem, Mr. Coughlin, is that this case has been pending for 7 months. You do not get along with any of the attorneys we've appointed to represent you in the past. The attorney-client relationship is hopelessly broken down. These motions you filed contain the financial inquiry to determine a public defender. They contain a motion you filed in the Justice Court and related to some case. I don't know what case it is, but apparently you have another case pending over there. You asked for a new trial, a notice of appeal.
What is that?
It has nothing to do with this case. Nonetheless, your request for appointment of legal counsel based on your dismal history with cooperating with lawyers in this court is denied. I'm confirming trial for Tuesday morning, October 29th at 9 a.m. We'll be ready to go for trial that day. This case is now 7 months old. There have probably been 5 or 6 hearings in front of numerous judges. I've reviewed the entire file at least twice. I spent the entire afternoon yesterday organizing and reviewing these files. I've made my rulings. The record is clear. Let me ask you this, Mr. Wong, is there anything further you'd like to add before I give Mr. Coughlin the final word?
I will only say this because I think it's important for the record. I did receive a fax from Mr. Coughlin on October 15, 2013. It has upper right-hand corner, it says page 1 of 4. Page 1 is the fax cover sheet, and attached thereto are 3 pages. What I received from the court today is different, than what I got from Mr. Coughlin. In fact, the 13 CR 3913 is entitled Request for Appointment of Public Defender plus Motion for NRS 178.405 Stay Recognition per February 28, 2012 and March 12, 2012, 11 TR 26800 order. My comment is that our office doesn't normally respond to requests for appointment of public defender because that's an issue for the court. However, as I just indicated, the 13 CR 3913 does have the notation quote plus motion for NRS, etc. So that clearly is a motion. We weren't served with it. And I am a little disturbed by the fact that Mr. Coughlin sent me a fax, but he didn't serve me with everything that he should have. The fax, as I indicated, was 4 pages, one of which is the fax cover sheet. What I received from the court today that was received or filed on October 15th is the 13 CR 3913 is 10 pages, and the 13 CR 3914 request for appointment of public defender is 9 pages. And so I just wanted to state for the record that whatever service that Mr. Coughlin is attempting, he's failing by not providing the entire complete copy. That's for the record. Thank you.
Sir, Your Honor, 178, NRS 178.589 goes to telecommunication lines. Mr. Wong's consistently characterized email as somehow other than a fax. I don't believe it is. I believe email is a fax under the definition of facsimile machine under 178.589, which references, I don't have it committed to memory, but it's something that refers to telecommunications lines. And I went and looked up the Telecommunications Act of 1996 and saw other definitions of telecommunications lines within NRS. There's not anything I found within NRS or Nevada law that specifically defines telecommunication lines. In that regard, I think it would be appropriate to take perhaps the definition out of the Telecommunications Act, which, as I understand it, would include email. So where Mr. Wong says, on one hand he tells this court, well, I've been emailed hundreds of things by Mr. Coughlin, but I haven't been served any discovery, there's an incongruity there that I submit is bordering on a violation of 3.1, 3.3, or 3.4. Further, with respect to Mr. Wong's contention that he was not served complete copies of either of these 10, 15, 13 motions for counsel, which, by the way, may not be ruled on by the presiding judge. Mandatory authority in Nevada, 1408 Indigent Defense Order and 80K 411 mandates that a judge other than the presiding judge rule on motions for appointment of counsel and or to establish indigency. Copies of these filings were beyond, I believe they were emailed, which would satisfy any deficiency referenced in the facsimile Mr. Wong references under 178.589. They were also placed in the Dropbox that I myself personally, in front of the City Hall building for payments, which I've been told will get to the city attorney.
Notwithstanding that fact, the court did get the original of what you filed. And here's my synopsis. You've been given plenty of time, and you have filed probably motions in excess of 1,000 pages. The motions that have been timely filed have been ruled on by the court and have been denied. Motions which have been filed, or pleadings which have been filed, or requests which have been filed in not a timely fashion have been denied. Motions and requests which have been filed not in compliance with state law or state statute have been denied. The matter will be going to trial next Tuesday morning. The court will be in recess. I'll see you gentlemen Tuesday at 9 o'clock. Thank you both.
Thank you.
Thank you, Mr. Coughlin. Thank you, Mr. Wong, for your time this morning.